Please start the session. Bhavana ma'am is here. You please start the session.
Yes, sir. Yes, sir. Yes, sir. Just a minute. Am I audible?
Perfectly audible.
Am I audible, sir?
Yes,
Okay.
yes, you are.
Good morning to all respected dignitaries, distinguished resource persons, faculty members, my dear participants. I am Vasda Shafkat, student of Department of Law, Central University of Karnataka. It is with great honor and privilege that I welcome you all to the plenary session 1, Multidimensional Perspective of Criminal Jurisprudence, on behalf of the Department of Law, Central University of Karnataka. Over the next 50 minutes, we will explore criminal jurisprudence from restorative, cultural, and futuristic global viewpoints, a truly multi-dimensional journey guided by three prominent scholars from South Asia and beyond. To begin the session, I have the honor to introduce our first esteemed speaker, Professor Jeeva Niriella ma'am, Professor, Faculty of Law, University of Colombo, Sri Lanka. Ma'am started her academic journey in 1993 and has since held many prestigious positions at the university and national levels. Her career is marked by remarkable contributions. She was the head of the department, deputy director of the virtual campus, and has served on several governing and advisory boards in Sri Lanka. She was awarded the national honor of Deshbandhu by the Democratic Socialist Republic of Sri Lanka in 2019. She has played pivotal roles in shaping victim and witness protection laws, criminal justice reforms, and gender inclusivity in governance, including her appointment as the first female government director of the Colombo Stock Exchange. Her research spans human rights, criminology, victimology, and justice system, and she has presented over 50 papers across esteemed global conference. We warmly welcome you, ma'am. As now it is my privilege to introduce our second speaker, Professor E. Prema ma'am, professor at VIT School of Law, Chennai, India. Ma'am holds a PhD in intellectual property and international law, awarded in 2015 by the University of Madras, and has been actively involved in legal academia since then. Her areas of expertise include international law, constitutional law, and intellectual property right. She has participated in global academic collaboration, including the Erasmus Plus Staff Mobility Program, and has co-organized international conferences on intellectual property and legal frameworks. She has contributed to prestigious academic publications, including book chapters, addressing complex issues such as Ponzi scheme regulation and transfer pricing in taxation. She has also presented numerous research papers at national and international seminars and workshops, covering topics such as gender justice, digital jurisprudence, cyber law, and criminal procedure. We warmly welcome you, ma'am. Now it is my honor to introduce our third distinguished speaker, Dr. Bhavana Mahadev, ma'am, lecturer in law, University of Technology, Mauritius. She holds an LLM degree and is an accomplished academic with a multidisciplinary research focus spanning corporate, financial, and economic law. Her work explores pressing contemporary issues including digital law, regional integration, artificial intelligence, sustainability, anti-money laundering, and corporate criminal liability. She has contributed to several impactful publications such as analysis of board characteristics and environmental sustainability, regional cooperation through SADC, Vietnam's social welfare model, and the indivisibility of human rights during COVID-19. Her research also includes comparative legal studies on virtual assets and money laundering across Mauritius, Japan, and South Africa. We warmly welcome you, ma'am. Now, with a great pleasure, I invite our first speaker of this session, Professor Jeeva Niriella ma'am, to deliver her keynote address on the topic, Restorative Justice as Global Narrative, Bridging Local Practice and Universal Global Ideals. Ma'am, we welcome you to share your valuable thoughts with us. The floor is yours, ma'am.
Okay, I hope I am audible and visible to you all. And my voice is also very clear to you
Yes.
to understand what I'm trying to say.
Yes, ma'am. Perfectly
Okay.
audible, perfectly visible, ma'am.
Yeah, thank you, Dr. Jam. And thank you for that very generous introduction on me. So I was given a very short notice, therefore I prepared a presentation, but there is no any PowerPoint presentation as I usually use that. I obtained this is from my ongoing research, what I'm trying to share with you today. So having said that, let me to welcome all of you, all the distinguished guests, the other speakers and esteemed colleagues, all the students, the faculties and ladies and gentlemen. And this is the greetings and the blessings from Sri Lanka and with a very warm good morning. So my dear friends, and it is again an honor to speak at this esteemed gathering hosted by the Department of the Law, School of Legal Studies, Central University of Karnataka on the profound theme of from micro-narratives to meta-narratives, remaining criminal jurisprudence in a globalized world. So, my dear friends, today I have chosen a topic to discuss with you that is restorative justice. As I said that earlier, it is one of my ongoing research work on global narrative, bridging local practice and universal global ideas. So, my friends, restorative justice, as we discuss on that particular concept, it is not merely a concept or a method of dispute resolution, but a powerful global narrative capable of transforming how societies conceptualize crime, harm, and healing. As Hoazé, popularly known as the grandfather of restorative justice, defines RJ as a process involving those affected by an offense to collectively identify and address harms, needs, and obligations, aiming to heal and mark things right. As John Braithwaite, I think he's very popular scholar in India as well, who is designated as the father of restorative justice, says that RJ is a process where all stakeholders in an injustice discuss its impact and decide how to repair the harm. These definitions highlight that RJ, at its core, seeks to repair harm done to the victim through dialogue, accountability of the offenders, participation of stakeholders, and the reintegration of both victims and offenders into the social fabric. It challenges the dominant retribution paradigm by emphasizing relationships over punishment and reconciliation over mere penal sanction. So RJ is more than a reform to me, and it's a paradigm shift. Since I advocate to restorative justice, including victimology. And at its spirit, RJ is a theory and practice of justice that emphasizes healing over punishment, accountability over condemnation, and rebuilding of relationships over retribution. It centers the needs of victims, the responsibilities of offenders, and the roles of communities in repairing the harm caused by crime or, in other words, conflicts. In recent decades, RJ has risen from the margins to mainstream. It is now part of global conversations in justice reform, conflict resolution, and peace building in the conflict world. This growing acceptance marks a significant transformation, one where justice is no longer merely a punitive mechanism enforced by the state, but a dialogical process shaped by community values and human dignity. Therefore, there is no doubt about that RJ is very much important in criminal jurisprudence in globalized world. So let me to just take you through very quickly the history of restorative justice to complete my the talk, otherwise it is not completed. So restorative justice, as always, people are trying to say that it is not a modern intervention of legal reformers. It is the re-emergence of age-old wisdom where we had earlier. So one example I can tell you that Aotearoa, New Zealand, Maori traditions embed justice within Wanangantanga, the network of relationships and mutual obligations that bind the community. The second example I want to take you to endorse my idea. Many African contexts, the Ubuntu philosophy affirms that I'm because we are, making the reconciliation more imperative. In early India, your country, restorative justice principles were embedded in panchayat systems, it's very old, and Dharmarashtra's traditions focusing on reconciliation, restitution, and community harmony. Dispute resolution aimed to restore social balances rather than impose purely punitive measures. Now, your neighbor, Sri Lanka. Restorative principles were evident in Buddhist legal traditions. Buddhist is the main, the majorities worship the religion, though it's a philosophy. And village councils we call Gam Sabhas, which sought reconciliation and harmony over retribution. Justice focused on repairing relationships and restoring communal balance. So the First Nations communities in Canada have long employed healing circles that focus on repairing both personal and communal harmony. So in jurisprudential theory, RJ aligns closely with communicative theories of punishment, which hold that crime violates a moral relationship that must be restored through dialogue and recognition. John Braithwaite's concept of reintegrative shaming has been particularly influential, suggesting that offenders should be condemned for their actions only, but they should be welcomed back into the community once they have made amends, means they changed or rehabilitated. Over the years, my dear friends, RJ has moved from traditional practices to law. And today it is seen that it was marked by key international frameworks, policies and strategies, which I can interpret as my language and my interpretation as the global narrative. In other words, in the international embrace of restorative justice has accelerated, especially over the last 2 decades, transforming RJ from localized practices into global justice narrative. I would like to mention a few of them that I consider as more significantly. The first one is United Nations Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. We mostly discuss that under victims' rights. It supports victim participation, active participation, and reparation aligns with RJ values. The next one is US Basic Principles on the Use of Restorative Justice Programs in Criminal Matters, adopted in 2002, which provided international legitimacy for RJ values. The next one, UN Rules for the Treatment of Women Prisoners and Non-Custodial Measures for Women Offenders, which was adopted in 2010, popularly known as Bangkok Rules. It encourages RJ and non-custodial measures for women offenders. We can't forget Tokyo rules as well, where the non-custodial measures are warranted as a blanket rule that for each and everyone considering RJ values. Moreover, RJ aligns strongly with the Sustainable Development Goals, particularly SDG 16, which calls for peace, justice, and strong institutions. Restorative justice operationalizes this goal by promoting inclusive and participatory justice systems that reduce dependence on incarceration, strengthen community bonds, and provide access to marginalized readers. There are some other regional wise as well as other the directives wise, some of the international directives and the strategies that we adopt. So one is United Nations Economic and Social Council. The other one is Council of Europe recommendation, the resolution which was adopted in 2018. And the last one is European Union Victims' Rights Directive. So then let me to take you through very quickly, because the 15 minutes are given to me, to discuss with you how the local practice with universal ideals and how it is now today we can see. So there are 3 guiding strategies emerged so far in RJ. So, and the illustrations that I am going to declare with the share with you can show that how RJ bridges these local global nexus. So then the first guiding the strategy is cultural specificity with universal safeguard. So my dear friends, RJ processes must be rooted in local traditions to maintaining legitimacy, yet they must also be underpinned by universal human rights protections, particularly the rights of the victims, which is very, the limited focus is attracted by many of the jurisdictions. Due process of offenders, well known and applied by many of the jurisdictions, or I can say that almost all the jurisdictions, and safeguard against coercion. The second guiding measure is under RJ, institutional embedding without bureaucratization. So one of the examples I can share with you, New Zealand's youth conferencing, and the other one is Norway's mediation boards. But we can consider the local adalat system as well as our Sri Lanka's Mediation Board Act. So then it gives you a kind of the smooth maintaining with the community involvement in conflict resolutions, but it is come under criminal matters as well. The third one is victim-centered approaches, which is very much important. RJ must ensure that victims are not actually token the participants, but active agents in defining and engaging in the final outcome. This bridges the moral authority of local practices with the rights-based discourse of global justice. The classic example I can share with you, the Assistance to and the Protections of the Rights of the Victim and Witnesses Act, which was earlier enacted in 2015, thereafter fully refined into another act. We call it Act number 10 of 2023. So then the last one is technology as a bridging tool for the application of the RJ. So digital RJ platform accelerated by the COVID-19 pandemic that show that the promising exceeding geographical boundaries of RJ. But however, one thing you have to be carefully consider the cultural sensitivity and ensure genuine participation of the people rather than virtually. We can sometimes see that one-on-one, the very fruitful outcome rather than that we are meeting one-on-one. So then there are a few others that I can share with you. One is Rwanda, one example, Rwanda. So then the genocide took place in, the more than 100,000 accused were brought into the justice system, where the formal justice system was not sufficient. So then the RJ mechanisms were considered, especially the Truth Commission, the reconciliation and dialogue, which was very successful than the formal trials. Sri Lanka, we have the Mediation Board Act number 72 of 1988 that also has the spirit of RJ enabling trained mediators to settle minor criminal matters through healing, dialogue, and agreement. As far as India is concerned, so as I said that we had earlier the Panchayat system, it remains one of the oldest restorative life models, but today you can see that how Lok Adalat family courts aim humanize justice with diversion and child welfare programs incorporating RJ principles. So then South Africa, which is very much the famous one all over the world, that is Truth and Reconciliation Commission, how it was supported with the storytelling and through the dialogue to heal the wounds that they had in the conflict. So then, how much these examples revives the local traditions adapted to global justice aims, so you can see that despite this promise, RJ faced significant criticism. I just mentioned the criticism, but not going to elaborate it. The first one, risk of coercion. The second one, power imbalance. Now see, sometimes between victim and offenders, they may distort it may be distorted the outcomes, because if the victim and offender, they belong to a totally different social strata. So then the state instrumentalization. The fourth one, the institutional recognitions, very clearly say that it is the end of the criminal law. The other one is social, cultural gaps challenge restorative justice. That is by causing misunderstanding that can undermine trust, distort intentions, and weaken the processor's legitimacy. So the solution lies in strong ethical guidelines, training for facilitators, and independent monitoring mechanism. Without these, RJ actually the risks becoming a good procedural formality rather than a transformative practice. So let me to conclude that, since I have 1 or 2 minutes left with me. So in conclusion, my dear friends, restorative, I want to reiterate that restorative justice is not a fixed model, but a living bridge, linking the global and the global, the traditional and the modern, the personal and the political. If carefully navigated, RG can serve as a bridge between cultural heritage and global human rights, between individual healing and systematic reform. In re-emerging criminal jurisprudence for our globalized era, which is to say that crime is not something against state, but it is harm done to environment or any of the living object in this world. We must ensure that the justice remains not only a matter of law because of that reason, but of humanity, dignity, and relationship. Restorative justice, when practiced with dignity, humanity, and cultural realization, has the power not just to reform our justice system, but to transform our society. Therefore, the message I want to give you to take you home and do research or consider in your research work, as well as your teaching and learning in the discipline of law, that is, let us choose justice that listens. Also see that justice that restores and justice that transforms. So take these 3 points and try as much as possible to implement your justice system through the research, teaching, and learning. Thank you very much.
Thank you so much, ma'am, for enlightening the session. Your deep insights into restorative justice and the balance between local implementation and global ideas have set the perfect tone for today's discussion. We were sincerely grateful for your valuable contribution, ma'am. Now I take the honor of inviting our second speaker, Professor E. Prema ma'am, to deliver her keynote address on the topic Perspectives of Criminal Jurisprudence Related to Cultural Practices. Ma'am, we now invite you to express your valuable perspective with us. The floor is yours, ma'am.
Thank you so much, Ma, for a generous introduction. And first of all, I thank Professor Dr. Basavaraj for giving me the opportunity to present before you, and also Dr. Jayanta who is a very good friend of mine, and he was a colleague here before he joined the Central University. So thank you so much. And also, I'm very grateful thanking Professor Dr. Jeeva Niriella ma'am, because I know her while she gives the very valuable insights and advice for my LLD, which is on cultural protection, while it is going to be the attacks made during the conflict times. So I know ma'am very well, and it was a wonderful presentation, ma'am. Thank you so much for the insights you have given. So now I'll just, I don't have a PPT, but still I could just talk to you about a few of the interesting things where my topic goes as a perspectives of criminal jurisprudence related to the cultural practices. I could hear Jeeva ma'am previously discussing very interesting facts where it is going to be comparison and also at the international level. So her presentation gave us an insight. And as I was telling you, my present research is the protection of cultural property during armed conflicts. So that is my current research. I'm doing my LLD on that. So I just thought, what would be the contribution of India, even at the global level? Because everyone knows how it is going to be the practice of yoga, which is established in the international arena. And India was been staging it in a very fantastic way, and it was widely accepted across the globe. So that is how India is being seen. And while analyzing all these things, how the problems, the cultural practices in India really is bothering us. And there are a lot more things which need to be refurbished or which need to be revived while it is going to be the cultural practice. Not exactly with the religion alone. I'm not backing up any specific religion, but the commonly known practices, apart from what religion you belong to, you being an Indian, know many of these practices you have seen or you have heard. So only 4 to 5 things which comes under the cultural practices I'm going to discuss very clearly. And what is the responsibility of India here? I could tell that as an example, I gave you how we have established yoga to be a very good cultural practice, which is having the historical ancient practice, which is acknowledged worldwide. Similarly, how we have to enhance, India have to enhance itself with the other cultural practice, which still is going on, and the relationship with the criminal jurisprudence, how these practices have been punished under the criminal laws in India. But still, these things are happening. That is a sad part, being the person with legal knowledge. We all need to understand, and what is the contribution to the society, it is with us. So I again could tell, one need not be rebellious always to tell and change the society, where the criminal jurisprudence also says that there is a way, there is a method where if you are going to, the motive is different and the action is different, which leads to a criminal act. So this confusion in the society is there, where people like, who knows law and who is professing law and who is practicing law need to come up and change the society, the way the perception, a cultural practice can be made, and it cannot be barbaric. It cannot be something which is against humanity. So that is the understanding. And I could also understand how the punishments are being with the Roman practices and the transitions and things where we are talking about restorative justice and everything is being practiced and understood by civilized societies and nations. So this need to be coming into the society deep rooted, and then change the cultural practices which is harming others or sometimes even animals. So we just, I as a society tell that we back up them and justify them, and even we digest it, understanding it to be a religious practice. So cultural practices are also covering up the religious practice. So that is one thing. So on the other hand, I can come out now with few of the examples. One which is going to be called as Talai Kootal. This practice is being found in the states of, southern states. And the example I'm giving is from Tamil Nadu, a very old practice. If I'm going to explain, maybe you could also understand such kind of practices in different names is being practiced in different states in India, where this traditional practice, which is called as in English senicide, killing of the elderly. So it is one cultural, practice where you can also tell it to be euthanasia, a kind of a thing. When the old elderly people are bedridden or not in a position to do their work on their own, and they are too very old, the decision of the community as a practice, it is not done hidden. It is made known to a small community of their own, the relatives. In front of them, in one of the practices which come under Talai Kootal, they give the oil bath to the person to whom this particular practice is going to be performed, and a handful of paddy is being put inside the mouth of the person, and then leave them to die. And there are also other things like giving the oil bath and leaving them in the cold mornings, so that they get high fever and the temperature is not treated and they are led to die. So it could be justified under mercy killing, but what the particular elderly person thinks cannot be, assessed. Maybe they themselves also don't want to live in the society like this, bedridden, or having the non-functional organs like, the hands, the legs, or anything. But it is against the nature. It is a forceful death, which is against the nature. So this comes under, violation of Article 21, and this practice is here and there, like child marriage, which is happening across. This is one practice where we have laws like Maintenance and Welfare of Parents and Senior Citizen Act 2007, and also a few amendments have come up where it says even taking care of the elderly person is going to be the responsibility of the daughter-in-law, and also how it is going to be the son-in-law, where the act says the responsibility of the daughter and the son to take care of the parents. And it is the maintenance which could be given and taken care of them properly. And there were also few of the decisions taken by, the collectors of a particular district in Tamil Nadu here, where he had moved to the courts that the parents who have given the, property to the son and daughter or their legal heirs can take back while they are not being treated well. So you could see how it is going to be the interlinking of things where you can just stop these activities, not to the criminal activities to that level, but it could be stopped while it is going to be a matured thinking, a civilized thinking by the society. Because maybe it is some half a century back, the society was not educated that well, but today we have the community, the basic knowledge, not only by a basic education, but also the technology had influenced where people realize what the real fact is. So things like this happen. And I could tell very importantly and very disturbing cultural practice, which is based on caste system. I could say this caste system is very specific for the Indian community, and many of the European countries or the Western countries doesn't know that much about the caste system. They have heard and they are surprised to hear how this caste system work in India, because widely everyone know across the globe about the religious discrimination and also the religion based differences which is there. And this particular problem, which is based on caste and sometimes also religion, is the honor killing. So everyone knows about it, and I'm not proud to say, while it is going to be the important cases and a recent judgment which is being given by the Supreme Court. The issue actually started in 2003, where the famous case of Kannagi Murugesan, which had happened in 2003, where it is going to be the the girl from the one of the backward community marries or gets into love with a lower caste community, caste, and the same was not acknowledged by the family of the girl, and they killed by poisoning the girl and also left the boy to die. So this is one sad thing where we talk about, we as a legal person, the person who has the legal knowledge, it could be researchers, students, advocates, anyone, professors, where we don't acknowledge, we talk about no discrimination on any ground, but this kind of thing, which is too very disturbing, it is carried out. Because very recently in Tamil Nadu, there was a case where a person named Kavin, they are just making the investigation whether that is also a honor killing, because this person, he tried to talk to another, the girl, even a friendly one or a love, expressing his love, it was not accepted by the community. All are educated, and this affinity towards a particular caste or a religion, I think and everyone believes that it is an uncivilized one. It's not word by words we can just tell that no discrimination, because for me any kind of affinity is a discrimination. So that leads to a problem to the highest of a criminal activity. So such kind of thing. And there are practices where it is Kap Panchayat, which in many of the rural villages, rural areas in India today, even today, which is decided specifically on honor killing issues, and they kill the bride and the groom, or the two person who are into love, and then it is accepted by the family, and the panchayat also backs up this kind of activity. So it is totally not made known to the society, or it doesn't reach even the police station where they could not intervene. It is being made known. And while it is going to be the criminal jurisprudence, all these kind of the two things where it is going to be amounting to murder and a culpable homicide, and the Bharatiya Nyaya Sanhit or IPC had given remedies, but still such kind of problems are always there. So now I just want to talk about the animal cruelty, because it's very important. The international courts and like ECTHR, the European Human Rights Courts, and also while it is going to be the Indian courts, the protection of animals are being looked through the lens of human rights. So that is very, I could feel how it's going to be interesting. Not only the fellow human beings, but also the fellow living beings need to be looked into or taken care under the human rights perspective. So that is a lighter version to mold the society, and not only making them to be educated, but also much civilized. While using the word civilized is going to be a better understanding. So that's the reason Indian courts just make and to realize the society that in a lighter version, when it is being educated, awareness is being created under the human rights, and it doesn't lead to a criminal act, right? For instance, while it is going to be the prevention of cruelty to animals, it's a very old act, 1960, and one of the incident in Tamil Nadu, the Jallikattu practices, where the animal is being involved in a kind of sport, and there was also protest while this is being taken before the courts, or even it was reaching to a decision. But the conflict between the practice and also how the practice is being professed, that was understood by the legal community. And this practice of Jallikattu, where in a festival, the farmers' festival, Pongal and Sankranti, which is famously known across the India, getting into the cows, male cows, to perform the particular sport, the Tamil Nadu government was permitted to make revisions and also the particular practices not to involve any cruelty, like beating them or giving them, alcohol, or making a cruel treatment of the was not permitted. So the practice was actually refurbished. They just involved and the practices to protect under Article 29. So the court had a very balanced perspective, not to curtail the practice of Jallikattu, but it advised and also made, and the Tamil Nadu government made an ordinance how this sport can be performed, and it is being watched by a welfare board of the animals very regularly, because it happens every year. So that is one perspective. And another important practice of killing the animals as a sacrifice. So that is a very cruel thing, which many community, even in the small, rural areas, still they do it. But how it is going to be, this practice will be a helpful for, which is against, or many of the community doesn't like it, because it creates unnecessary pain and suffering to the animals. So these two things, while it is going to be animals, and there are much more decisions where the title of cruelty, and India was able to create jurisprudential perspective that we respect animals, and it amounts, while it is going to be protection of wild animals from smuggling their skin and everything. So that also comes into picture, how we give India gives protection for animals too. So lastly, no, not lastly, I could tell why it is going to be the Sabrimala temple case, right? Everyone knows the Indian Lawyer Association was State of Kerala 2018, while it is going to be the rights of women, and many perceptions and different opinions while the decision was being taken. While this is going to be such kind of cultural practices, it could have been led to an offense where somebody is stopped going on to visit a temple. And many questions came, why it is going to be women want to just break this cultural practice only in Sabrimala. Why don't they choose the same God where they are permitted? So that was one layman understanding, and the court considered the point of whether certain discrimination is made based on gender and how this can be curtailed. And of course, a great decision of 4:1, the majority, and Justice Indu Malhotra, her decision was the dissent opinion, though her perception, I cannot blame her, but an interesting decision where she was talking about the practices by the religion and interference of the state, whether it can be permitted or not, was very different, though it is a dissent opinion. On the other hand, it is going to be 4:1 majority held that the temple practice of prohibiting women of menstruating age from entering was unconstitutional. So there was going to be the petitions later have been made, and it was looked in a different perspective. So you could understand how the dignity of women and the equality principle was being established. And finally, I don't know, I have time, but still I could tell where it is going to be vandalizing the idols and also religious identity. India is known for its secular nature, where the Constitution of India permits with a very broader hand and a civilized opinion of the learned people who have made the Constitution, and also how the inclusion of the term secularism was being there. We respected for years together. On the other hand, while it is going to be the cultural practices and how vandalizing a particular for instance, the incidents happens in temple, or destruction of cultural or damaging of a cultural property, which amounts to a criminal act, and the same is being punished. And we have this criminal jurisprudence while it is going to be India. Provided, I could also quote you one incident where in our neighboring country, and we also accept the refugees from Bangladesh or the migrants from Bangladesh and help them out here in India, provided in Bangladesh the attacks and vandalizing the Hindu idols, which crossing the borders, we were permitted because we were brothers actually, while it is going to be Pakistan or Bangladesh concern. But this kind of events where the question of, are we civilized, are we understanding what we literally practice and the profess. So it is totally, the practices which need to be acknowledged, though you like it or not, or you don't belong to a particular cultural or religious practice, while it is not harming others. So it's very important for us to become civilized and very properly used. So from my side, I think this is what I just thought of discussing, because it's like varied opinions which the Indian courts have observed in many perspectives. I think I justified the opportunity which was given to me. So thank you one and all, and thank you Jayanta sir for giving me a wonderful opportunity, and the other coordinators and the student coordinator for encouraging me. Thank you so much.
Thank you so much, ma'am, for your enriching and thoughtful presentation. Your perspective on how cultural customs, cultural practices intersect with criminal law has provided a profound understanding of legal pluralism. Ma'am also emphasizes on that honor killing, that is an evil in our Indian society. We need to think about it. And we truly appreciate your contribution, ma'am. Thank you, ma'am. Now it is my privilege to invite our third speaker, Dr. Bhavana Mahadev, ma'am, to deliver her keynote address on the topic, an insight into the future of criminal jurisprudence in the global world. Ma'am, we warmly invite you to share your valuable insight with us. The floor is yours, ma'am.
Thank you. Thank you very much, Waska. So thank you very much, Jeeva ma'am and Prema ma'am. I have been listening to you and the speech was excellent indeed. So thank you, Dr. Jayanta, for the opportunity to be present here today. So taking into consideration the marvelous theme we have chosen here today, we have multidimensional perspectives of criminal jurisprudence present. So Prema ma'am and Jeeva ma'am, they have shared their insights on their different perspectives. So I would like to share my point of view today on the future of criminal jurisprudence in the global world. So I would begin by saying that when we hear about crime, criminal jurisprudence, so the words that come to our mind, for example, investigation, trial, so the sole motive of every investigation or trial, it is to administer justice, to find out the truth, which can only be achieved through a fair, just, and a proper investigation. So we all know that this is an attribute of Article 21 of the Constitution of India and encompasses two imperatives: unbiased, honest, just, and in accordance with the law. So the investigation, it must be free from objectionable features or infirmities that, they may lead to grievances from the accused, such as unfairness or ulterior motives. So the investigating officer, for example, they must be fair, they must be conscious, they must avoid any type of mischief or harassment towards the accused. So this investigation, for example, it must appear to be fair and just, for example, abstaining from any kind of conduct or impression that may give rise to a genuine apprehension in the mind of the accused. So, for example, if an informant police official in a criminal prosecution makes allegation and is asked to investigate, for example, then serious doubts may arise regarding their fairness and impartiality. So it is not necessary to prove bias, but it would be, I would say, it would be illogical to presume that the investigation would conclude false implication and result in a foregone conclusion. right? So accountability and responsibility, they are crucial factors in investigating agencies, leading to a flood of litigation in courts. So criminal trials, they are a threat to the society, and the state therefore has a responsibility to protect it by being responsible, by being accountable to the law-abiding citizenry. So the Indian criminal jurisprudence presumes every person accused of an offense to be innocent until proven guilty beyond reasonable doubt. So the prosecution must prove and establish the offense against the person, and the burden never shifts to the accused to disprove the charge. So if a doubt arises, the benefit of doubt should be given to the accused. However, proof beyond reasonable doubt, it is a guideline, and guilty individuals, they cannot get away with it. The maxim that we use, let 100 guilty persons be acquitted, but not a single innocent be convicted. This is changing worldwide, and it is high time that court
Hello, ma'am. Am I audible to you, Bhavana ma'am? Vasga, am I audible?
Yes,
Yes,
sir,
sir.
you're audible. I think ma'am has some connection issues from her end.
Yeah, ma'am. I request the participants to please keep a little patience. Ma'am will be rejoining us.
Sorry, am I still audible?
Yes, ma'am, perfectly audible.
Yeah, sorry, I lost, there was a connectivity issue, but
No issues,
right
ma'am, no
now I
issues.
cannot switch, I cannot switch on my camera anymore. So apologies for that.
No issues,
So
ma'am.
yes, I will continue. I really don't know where I lost connection, but yet I was talking about how criminal jurisprudence allows anyone to initiate criminal law except when a statute indicates otherwise. Right? So the Criminal Procedure Code outlines two independent agencies for taking criminal offenses to court, allowing private complaints to be filed and proceedings according to the law. So the principle of locus standi is foreign to criminal jurisprudence, except when a statute provides for the complainant's eligibility. So prosecution for serious offenses is undertaken in the name of the state, representing the people, excluding private vendetta or vengeance. So sections 154, 156, 167, 173, and 190 of the code, they outline the powers of police officers in investigating cognizable cases. So the Criminal Procedure Code defines cognizable and non-cognizable offenses, with the complaint being an allegation made to a magistrate. So a fair trial is a constitutional guarantee under Article 21 of the Indian Constitution. So the prosecution must therefore demonstrate fairness and judiciousness in investigation. Sterling worth, this is a generic term which is used to judge witness credibility. So suspicion cannot replace proof in a criminal trial, and the court must maintain the distance between conjectures and conclusions to avoid what we call miscarriage of justice. So the standard of proof in criminal cases, they should be higher than the crime itself, and the accused has the benefit of doubt when two possibilities are available. So statutes like the Negotiable Instruments Act of 1881, the Prevention of Corruption Act of 1988, they provide for presumption of guilt. Private defense is available only where an unlawful act is an offense. So the superior court must determine if failure of justice is a genuine issue or a disguised one. If a non-explanation of an aspect contributes to penalization, the court may argue that non-compliance with natural justice principles is the cause. So failure of justice can occur through unjust conviction or acquittal due to insufficient evidence. But the accused's rights must be protected. However, victims, they also have rights. So prejudice cannot be applied to criminal jurisprudence, and the plea should be related to investigation or trial. So if the accused can prove serious prejudice defeating their rights, they can seek benefits under court orders. Bail is a fundamental postulate of criminal jurisprudence with the presumption of innocence. However, some basic principles have been lost, leading to increased incarceration and longer prison sentences, which harms criminal jurisprudence and the society at large. So the justice system, it must be defended by courts, who must award proper sentences based on the nature of the offense and the manner in which it was committed. The aim should be to protect the society and deter criminals from achieving the law's objectives. The sentencing process should reflect society's conscience, and imposing sentences without considering the social order, it can be futile. The social impact of crimes, such as crimes against women, dacoity, kidnapping, or treason, they should not be overlooked, and they require exemplary treatment. So a liberal attitude or sympathetic view may be counterproductive in the long run and against societal interests. The punishment should be consistent with the atrocity and brutality of the crime, the enormity of the crime, and the society's cry for justice. So, for example, the death penalty jurisprudence in India has been widely debated, with life imprisonment being the rule and death as the exception. At the same time, criminal law based on human behavior aims to protect human rights and promote harmonious coexistence. So it addresses rights, duties, and upholding them, and is considered wrong when someone else's action or inaction places a person in an uncomfortable situation. So adjudication is the process of determining if an action or inaction is wrong and correcting it, with justice being the outcome. So criminal jurisprudence develops in situations where a person's action or inaction may impact a society's sovereignty. It aims to prevent harm to society by warning people not to do something, stigmatizing offenders, and suspending benefits. The goal is to shield society from wrongdoing, and the doctrine of victor and defeated has existed in international law, such as the United Nations and the League of Nations, which aim to safeguard human rights by controlling nation-state behavior and sovereign power. So, if we venture into that branch, this will never end. Therefore, in a nutshell, it can be said that both domestic and international laws are regulated to ensure that people can live comfortably and with dignity. This is also in line with the French philosopher Rousseau, who inspired French citizens to start a revolution for a change in sovereignty. All men are born free, but wherever they are in chains, they do not recur again. So constitutions around the world recognize these human rights as fundamental rights. Their foundations are liberty, equality, and brotherhood. Therefore, sovereignty will not be discriminating, Everyone will be able to live comfortably and with dignity, and there will be mutual concord so that members will grow closer to one another. The goal of all laws passed by legislature, they must be the same. When implementing the law, the executive branch must adjust its action to achieve these goals. And the court must evaluate whether the law is in conformity with these goals and whether its language and purpose fulfill them. It takes into consideration when an individual has committed a crime and, if so, how best to handle it within the bounds of the law in order to preserve or restore social harmony. So since liberty is a person's primary goal that promotes mental tranquility and helps to preserve social harmony, a wrongdoer is denied this freedom to the extent necessary. The two main methods for implementing the rules, they are the temporary or permanent restriction of one's ability to enjoy one's property and the temporary or permanent restrictions of one's ability to associate with others. So a person is given the chance to understand why such measures are necessary before they are adopted, allowing him to argue in a qualified forum that he has done nothing wrong, or that even if he has, he does not deserve the proposed deprivation. So the legislation aims to prevent or stop wrongdoing, aiming to maintain social order. Some wrongdoings are punishable by law, while others do not. So executive actions for peacekeeping and enforcement, they do not invite penalty. Law enforcement authorities must exercise caution, therefore, and prudence in addressing these issues. Now, preventive measures, they may also include forbidding individuals from joining certain groups, such as the Forest Act, Essential Commodities Act, or Prevention of Corruption Acts. So these measures, they are not comprehensive and they may not be comprehensive. The ultimate goal is to prevent future wrongdoing and maintain social order. So, as previously mentioned, right, if a person who has been deprived of their property or freedom, they are given the opportunity to express their opinion before forums established that they do not deserve to be treated in a way that the law stipulates. So for this reason, he has the right to counsel in cases involving public order, or an impartial body known as the advisory board decides if imprisonment is warranted. So high courts and the Supreme Court, they have the final say in determining whether detention is warranted through the exercise of their respective writ, jurisdiction, and appellate jurisdiction. So finally, I would say that when an action pertains to law and order rather than public order, a forum is established to decide the matter. When an action is considered a crime, the perpetrator is referred to as the accused and is put on trial in a court of competent jurisdiction using the process outlined in the Code of Criminal Procedure. So the Evidence Act provision, they are used to evaluate the evidence that has been presented, and the accused is found guilty once all the requirements for the offense are met. In certain situations, the accused is sentenced, while in other situations, the imposition of the sentence is postponed until the accused is found guilty of a crime for which they are believed innocent. So the judicial system's primary purpose is all around, boils down to discovering, vindicating, and establishing the truth. However, it will be sad to end on this note that sometimes this is not followed, leading to justice failure. Therefore, we conclude today by saying that it is crucial for legislature, investigating agencies, and the court to remind themselves of their duty to establish the truth. Thank you very much for your time. Dr. Jayanta, that will be all from me. Thank you.
Thank you, ma'am. Wasga, are you here?
Yes, ma'am. Yes.
Yes. Please proceed, Vasga.
Thank you so much, ma'am, for your presentation. Your views on emerging. With this, we come to the conclusion of this session. I sincerely thank all three of our distinguished speakers for their valuable time and for sharing their immense knowledge with us. To formally conclude this session, I now invite Mr. Arun Kumar Raju, Research Scholar, Department of Law, Central University of Karnataka, to propose the vote of thanks.
Arun, are you here? Arun?
Hello, sir.
Yes, ma'am.
Hello, sir.
Yes, ma'am.
Yeah, you call me, sir?
No, sir. I am calling Arun, the research scholar. Okay. Anyways, maybe he might be having internet issues. In the department, there is a lot of internet issues. So with this, I formally would like to extend a vote of thanks. I first express my sincere thanks to our all the three panelists, the Professor Dr. Jeeva ma'am, who from Sri Lanka has enlightened us and taken this hard work to deliver an enlightening speech. We have been given a very good idea about restorative justice. And next, I would like to extend my sincere thanks to Professor Dr. E. Prema ma'am, who has been a very much good mentor for me also previously, and now also we are working together on various projects. And as it is very nice to hear from her about the various cultural practices and those what are the dark side of our humanity, and we need to be very much concerned. And I think this her session will also definitely help in getting some research insights. I would also like to thank Dr. Bhavana ma'am, who have joined us from way Mauritius and has delivered her sessions, and it was nice, very nice to hear from her once again. She has been helping us. She has been delivering sessions for the department quite often in the previous occasions also. It is very nice to see you, ma'am. Now, I would like to also extend my sincere thanks to to Honorable Vice Chancellor of Central University of Karnataka, Registered Central University of Karnataka, and all the administrative and technical staff who has been working day and night and motivating us in organizing this type of events. I would also like to sincerely thank the main person behind the scene, that is Dean, School of Legal Jurisprudence, Dr. Basavara Samkubakadi sir, whose inspirations and whose authority is most important for persons like me to conduct such kind of events. I'd also like to thank the coordinators and the moderators. They have really worked very hard to make this plenary session a really lively one. Without their efforts, it won't have been possible. And at last but not the least, sincere thanks goes to all the participants who in this kind of working day also they have arrived in such a large number to attend this session. This shows the amount of trust they have on us. With this, I would like to declare the session as concluded. But before that, I would request all the chairpersons, except Jeeva ma'am. Jeeva ma'am will stay here. Prema ma'am, I have sent you the link for the technical session to please join the technical session. And then we have Bhavana ma'am. Bhavana ma'am, there is another separate link for the technical session 1C. Please join the technical session. And all the paper presenters who are from technical session 1B, kindly join your respective session, and who are from technical session 1C, please join that particular session. It will immediately start. Thank you.
Dr. Jayanta,
Yes,
I'm
ma'am.
actually checking that where the technical session link, whether I have received that. I can.
No, this platform will be for you, ma'am.
Okay.
There are two
Can
separate.
I use this the same one?
Yes, ma'am. Yes, ma'am.
Oh, yeah.
Here only it will start.
Thank you. Thank you.